Good afternoon, and hello, Lady Dorrian.
Hello, Edith. How are you?
I'm well. How are you?
Good. I'm fine. Were you in court this morning?
I am. I'm actually just across from the High Court in Glasgow. We're waiting for a verdict, so
Are you?
I'm assured that the jury are now out for lunch. So
Yes.
we won't be disturbed just now.
Be interrupted. Yeah.
Exactly. So we're so grateful to you for agreeing to come and speak to us today, and obviously you're speaking today about the death by driving sentencing guidelines, which have recently been approved by the High Court. So thank you very much for agreeing to do that. And got one or two questions for you that we'll just start with. So the first is really, this is the first ever offence guideline effective from the 16th of January of 2024.
Yeah.
Why has this been taken and why in relation to death by driving offences?
As death by driving offences can be amongst the most serious, complex and sensitive cases decided by the courts. They're actually relatively uncommon, but they're of enormous public concern because they have a devastating effect on the families of victims and others affected by the offence. In addition to that, there are particular challenges for judges in sentencing these cases. The circumstances can be highly complex. They vary significantly amongst the different offences. There's often a large discrepancy between the harm caused, which is somebody's death, and the culpability of the offender, particularly in careless driving cases, which could result from a momentary lapse of attention or a single error of judgment by someone who's never been in the trouble with the law before. And because there are comparatively few cases, judges may be less familiar with the particular issues for sentencing them. Research has also shown that there's a lack of public understanding and awareness of the law and sentencing practice actually in the public in relation to death by driving offences. And also as to the difference between dangerous and careless, and even about the full range of factors taken into account by the court. These were really the motivating factors in selecting these offences to have the benefit of a guideline.
I mean, you're absolutely right. These cases are just, I think because it's such an instantaneous and very often just catastrophic in every sense for so many different people, and it's trying to get the legal explanation over amid all of the emotional attachment to it that really probably, well, obviously needed some sort of clarity. So then what then would you say the benefits of these guidelines are, Lady Dorrian?
Well, we thought that there would be benefits, really for the reasons I've given, to both to the public and to the courts. It should help public understanding because it should improve awareness of the law and practice in relation to sentencing these offences. It should improve understanding of the complex issues involved. It should assist with predictability and, in particular, with explaining how decisions are made about sentencing and why. And from the judge's point of view, it should help by listing some of the key features relevant to the assessment of the level of blame and the seriousness of the offence. As you'll have seen, the guideline sets out aggravating and mitigating factors. It provides sentencing ranges for judges, whilst at the same time seeking to preserve flexibility and discretion that's always so important in every sentencing exercise. While nothing can make up for the tragic loss of life, we do hope that the guideline will provide clarity for bereaved families and others affected by death by driving cases and will be of real help to judges.
And so then what specific offences are covered by these guidelines?
They're all the death by driving offences, so death by dangerous driving, causing death by careless driving while under the influence of drink or drugs, causing death by careless or inconsiderate driving, and the tricky offences of causing death by driving while unlicensed or uninsured, and causing death by driving while disqualified, where the category or characterization of driving isn't the main issue. And for all of these offences, of course, the level of harm, which is one of the critical factors in assessment, the level of harm has been fixed by law. It's the death. And so it's the same throughout all of these offences. But there are significant differences. Different statutory maxima and the circumstances of culpability will vary considerably. And as I say, assessment of the standard of driving is critical to the first three of these that I mentioned, whereas for driving while causing death while driving uninsured or unlicensed or disqualified, that the issue really stems primarily from the fact that they shouldn't be driving rather than the quality of the driving.
Yeah. And then so the guidelines set out specific sentencing as well. So what sentences are outlined within this new guideline?
Yeah, this is the first guideline we've done where we've had a range of sentences included, and we've set them out based largely on current practice. The range for death by dangerous driving is only custodial sentences, and the highest point is 12 years, because that's the highest that has been imposed in Scotland in recent years. That's the highest in the range. It doesn't mean it's the highest that could ever be imposed. For death by careless driving, the range covers from community-based to custodial, although very few of these offences result in a custodial sentence. And for one that would attract a penalty beyond the range, it would be likely to have been charged as the more serious offence in any event. And the same applies for driving, causing death by driving under the influence of drink or drugs. Cases in relation to the uninsured, unlicensed, disqualified driver, there where the quality, if the quality of the driving becomes a significant issue, we would expect those would be prosecuted either as death by careless or death by dangerous driving. So the maximum sentences are noted in the guideline. They're not included in the ranges, but the guideline doesn't prevent the court imposing the statutory maximum in any of the offences. It can go above or below the range if it considers that's the most appropriate sentence. And the list of aggravating mitigating factors, they're not intended to be exhaustive. No guideline can cover every single eventuality. We've tried to capture the most significant, the most common ones. We've grouped them into categories to try to help: consequences, record, circumstances of driver, circumstances of offence, action at the scene, in a way to try to help sentencers compare related factors and indicate the general level at which the sentencing might come in.
And might you tell us a bit about just how the guideline developed, how it's been developed?
Yeah, sure. Developing any guidelines for us is a multi-factorial, multi-year actually exercise involving intensive research and engagement. On our website, we have published our development process. It's 8 stages, public consultation at stage 4. In the earliest stages, we gather statistical data on sentences imposed in Scotland for these offences. We sought the views of judges about current practice and about the key challenges they face in these cases. We tested an early draft of the guideline with judges, and we looked at sentencing statements. At the same time, we commissioned a number of research projects. There was a literature review looking at the available evidence on the sentencing of these offences here and in other jurisdictions. A study on public perceptions, including the perceptions of the families of victims, which is really important. And we had a nationally representative survey of 1,000 participants exploring public knowledge and attitudes. And that included scenarios on causing death by careless driving and causing death by dangerous driving. What was significant was that most respondents to the death by dangerous driving scenario selected sentences that were actually more lenient than the probable sentencing practice would indicate, which I think suggests that public attitudes to sentencing are actually rather more nuanced than they're sometimes given credit for being. And of course, we had discussions with other jurisdictions, and that led us to the next step, which was the public consultation exercise.
And so just in relation to the public consultation, can you explain about how that fed into the guidelines?
As we carry out a public consultation exercise, an open public consultation exercise for all of our guidelines, and we made that decision very early on. And it's not a mere formality. It's something that we really engage with. Every response is considered. It becomes part of an independent consultation analysis. It's a transparent process as far as we can make it. We publish the analysis. We publish a thorough report of our response to that and to the suggestions. We publish responses that we've received where we're given permission to do that. And in a way, the consultation here is a good illustration of how this works, because we made changes to the guideline following the consultation. It was strengthened in a number of ways. Aggressive driving was included in the highest level of seriousness for causing death by dangerous driving alongside racing. The list of aggravating factors was expanded. In particular, we added that the victim was a vulnerable road user, so a cyclist, a pedestrian, someone riding a horse, a motorcyclist, and that we thought was important. It reflects, apart from anything else, the hierarchy of road users within the highway code. The other thing we did was add an aggravation that the offence was committed whilst being pursued by the police in relation to causing death by dangerous driving. A police chase is one of many factors which might indicate a high level of seriousness. The factors that are likely to be present all point towards seriousness: excessive speed, disregard of road signals and signs, a prolonged deliberate course of bad or aggressive driving, and so on. And so that seems to be a pretty clear aggravating factor. And we altered some of the sentencing ranges. We removed driver inexperience as a mitigating factor, except in causing death by careless driving. And we took steps to strengthen understanding of the relationship between this guideline and our other guidelines.
And so what then were the views of the general public who responded to the consultation?
It was quite interesting. Sometimes people respond to us in making suggestions that we can't actually deal with. And I think they get frustrated when we can't actually make changes they feel strongly about, or where we decide against doing so simply based on all the research and everything else. An example is that a number of people raised the question of, for example, minimum or maximum sentencing and whether they should be changed. Now, that wasn't part of our remit. It would require legislative change. We couldn't. We can't do anything about those things. Otherwise, I think what we learned was what we had already learned from research, namely that the distinction between careless and dangerous driving wasn't always well understood. There was a lack of awareness about all the factors that are taken into account, and perhaps also the extent to which culpability varies across these offences. However, we did take steps to address concerns where we could, even if they were out with our remits. We published a new webpage setting out information on the rights and support services available to victims of crime and their families to address some issues that were raised with us. It's not direct part of sentencing, but we felt we could provide that information. And also another web page about the relationship between the different guidelines, because we thought that should help address any potential gaps in understanding about that.
And just on that point, we've spoken previously about the young persons guidelines. We spoke about that in a previous interview, but how then will this guideline apply if the person convicted is under the age of 25?
I'm glad you refer to being under 25 when convicted, because we do need to emphasise, I think, that the sentencing of young persons guideline only applies when the offender is under 25 at the time they're found guilty or they plead guilty. That's different from the general considerations that age or maturity at the time of the offence are always a consideration, because in those cases, that will only be one of numerous relevant considerations. Whereas in relation to when the guidelines are applicable, it's a critical one. Obviously, when a young person is being sentenced for these offences, all the guidelines will have to be, relevant guidelines will have to be looked at, and the judge has to decide the seriousness and the culpability in light of what the sentencing young person's guideline says. What I would say, I think, is that the imperative to treat rehabilitation as a primary purpose only applies within the confines of the young person's guideline. And there isn't otherwise a hierarchy of purposes. Which is most important will depend on the case. And the focus on rehabilitation doesn't mean that other relevant sentencing purposes are irrelevant. The ranges in this do apply to a young person, but it's for the judge who's heard all the circumstances to decide how to apply the two guidelines together. And of course, as we've said several times, it's not simply a question of applying a reduction to what you would give an adult. You have to approach it differently throughout the exercise. So that, I think, is probably the best answer I can give.
Thank you. So then is more work contemplated or underway to introduce more offence guidelines for other offences?
Of course, yes. We're developing a number of guidelines in relation to specific offences at the moment. We're working on rape and rape of a young child. We hope to hold a public consultation on drafts of these in the summer. We're developing guidelines on sexual assault, offences involving indecent images of children, and domestic abuse. We hope to resume work on environmental and wildlife crime next year. And we've also begun work on another general guideline, this time in sentence discounting, a much misunderstood area. And we hope that a guideline of that kind will help increase transparency and, in particular, understanding around this often misconceived issue.
Lady Dorrian, thank you so much for walking us through those, the guidelines and the thinking behind them, and also the various input that people, including the public, have had. That's been so...
It's a pleasure as always, Edith. We're always very keen to publicise the work of the Sentencing Council and to give as much information both to the public and the profession as we possibly can. So it's always a good way of helping us do that.
Absolutely. We're most grateful to you, and thank you for your time, Lady Dorrian.
Okay, thanks
you
very much. See you.